This is what an actual lemon law case looks like against GM. This video is a must watch for anyone with a pending lemon law claim or a potential lemon law claim against any manufacturer, but you'll get extra value if you have an actual GM vehicle. That could be a Chevy, GMC, Buick, Cadillac, or Hummer. Make sure to watch until the end where I discuss GM's most effective defense strategy to these cases and how we counter that strategy to win big time and time again. If you're wondering who I am, my name is Sina Rez Law. I am not only a huge car fan, I'm also a California lemon lawyer. I'm the owner of Sina Rez Law, where we specialize in lemon law cases. In this video, we will cover how to qualify under the lemon law, the most common settlement types in the lemon law, how GM specifically likes to negotiate in lemon law cases. We will also discuss what a lemon lawyer actually does for you. Is a lemon lawyer really free or not? And we'll talk about GM's most effective defense strategy and how to overcome that. We have so much to cover, so let's jump right into it. For starters, let me start with a disclaimer. This is going to be focused under California's lemon law. Every state has its own lemon law. They're all similar to a large degree, but they all have their own nuances. So if you're out of state, you can still get some value out of this, but make sure to consult with a local attorney to have the best results. To really boil down the lemon law, it's a law that allows you to get a refund for your vehicle if it's had too many problems within the warranty period, or those problems take too long to fix. So what's too many? Some people will mistakenly think that it has to be 3 repairs for a specific issue, but that's not necessarily true. It really depends on what issue you're having. Most people will agree that you need to have at least 2 repairs, but we've even had successful cases for people that only had 1 repair. So let's say that you have issues with your transmission. You may only need 2 repairs to have a successful lemon law case. But let's say you have problems with your radio. The radio isn't as vital of a component as the transmission is, so you may need more repair attempts to have a successful lemon law case. What's important to note is you can have a successful case for both types of repairs, both something really significant like the transmission and something that maybe isn't vital like the radio. So how long is too long? The lemon law says that if you've had over 30 days of repairs, meaning 31 days or more, that's another way to qualify. So not only can you qualify by having too many repair attempts, you can also qualify by having too many days under repair. You do not need to have both. But there is a way that both of them work together where, let's say you have only a few repair attempts, but you actually have a decent amount of days under repair, not quite 30, those two can combine to have a successful case as well. But what's really important to note is that under the lemon law, we're focused on warranty repairs. So if you've had repairs that fall outside of the warranty, maybe because you've put too many miles on your car or the car is too old, those repairs will not count towards a lemon law case. Also, if you have the type of repair that's covered under a goodwill, maybe because the manufacturer still covers it for you for free, but it's not necessarily a warranty issue, those repairs will not count also. To qualify under California law, you also need to have bought or leased your vehicle within California. You have to have gotten it from an actual dealership, so no private party transaction. When it comes to used cars, things start getting a little bit more complicated. California's lemon law has changed several times within the past few years on how it handles used car purchases. One thing that's easy to say is if your car is certified pre-owned, you definitely still have lemon law rights. However, if your car is purchased used and not certified pre-owned, it's a little bit more questionable. So for example, if you got your car from CarMax, you may not necessarily have lemon law rights. However, if you got your Chevy from a Chevy dealership, the chance of you having lemon law rights is significantly higher. Another really important thing to note is that if you have a used car, no matter what age it is, no matter how many miles it is, that came with a warranty at the time of sale, you have lemon law rights. There may be very specialized lemon lawyers that take on those types of cases. For example, at our firm, we're only specialized in suing the manufacturer, so we don't take on those particular types of cases. Now that we understand some of the basics of how to qualify under the lemon law, let's move on to common lemon law settlements. There's really 3 types. One is a repurchase, one is a replacement, and the last is a cash offer, also known as a cash and keep. Let's actually start by diving into a replacement. A replacement vehicle can be requested, but the manufacturer can still be complying with the lemon law and say, no, I'm not going to offer you a replacement vehicle, so long as they still offer you a repurchase. That means that we can't force a manufacturer to offer you a replacement vehicle. However, many manufacturers still will do that. GM, for example, will still offer a replacement. It just seems to be that they won't do that if you're actually represented by an attorney. So this is one of the very, very few exceptions where I would say it may be better if you're dead set on wanting a replacement vehicle that you actually don't use a lawyer to get that. But in my opinion, a replacement is actually the worst of the 3 settlement types. I actually think a cash offer or a repurchase tend to be better. So I think wanting a replacement vehicle and being dead set on that is actually a mistake in most situations. Now let's talk about a repurchase. In a repurchase, 3 things happen. You get a refund of your money. We're going to come back to this in a second. The loan on your vehicle, if you have one, gets paid off by the manufacturer, and the manufacturer pays your attorney's fees, so you don't have to pay any. When it comes to the refund of your money, we start by adding up your down payment, any trade-in value, all of your monthly payments, your registration payments, if you've had any tow expenses, rental expenses, things like that. And from there, the manufacturer is allowed to take some deductions. It totally depends on the specifics of your case. Typically, there is a mileage deduction. The mileage deduction is meant to compensate the manufacturer a fair amount based on how many miles you drove the vehicle before you started bringing it in for repair. That means in the average lemon law settlement, a person does not get back 100% of their money. That is, however, entirely possible, and we get those settlements all the time. It's even possible to get back more than what you spent on your car. The last of the 3 settlement types is a cash offer. In a cash offer, the manufacturer compensates you for your trouble, pays your attorney's fees, but does not pay off the vehicle and does not take the vehicle back from you. This could be good or this could be bad. It just depends on how much they're offering you in a cash offer. Now let's apply this a little bit more specifically to GM. Let's say that in a cash offer, you are going to get back $15,000 and your attorney's fees are $10,000. GM will write one check for $25,000 and make it out to the law firm and you together. The law firm then has to split up the money and give you what's called a settlement breakdown, where they distinguish that you're going to be getting 15 of that $25,000 and 10,000 will be going towards attorney's fees. This may feel like you're paying attorney's fees, but you're not, because GM set aside $10,000 in this example to go towards the attorney's fees. Now let's talk about how GM likes to handle negotiations in lemon law cases. GM absolutely loves cash settlements. They will offer you sometimes even more than what you would get in a repurchase in a cash settlement. We'll talk about why in just a second. Accepting a cash settlement has some pros and cons. It means that you still have the vehicle. So if you have a lot of equity in the vehicle, it means you could turn around actually and sell the car tomorrow, and you can basically double dip. You can make money from the sale, and you can also make money from the case. As long as you're accepting a cash settlement, then the vehicle technically will not be a lemon, and you don't actually have to make any specific disclosures when you're selling the car. Alternatively, you can keep driving the car, and if you have your warranty is still in effect, and if you have more repairs, you can keep taking the car into the dealership. So there definitely are some advantages to a cash settlement. However, if you're not interested in a cash offer and your repair history is strong enough, you absolutely can still get a repurchase. The only real exception to this rule that we've seen is when it comes to the Chevy Bolt. For reasons that are way too complex to go into in this video, GM insists on only making cash offers when it comes to the Chevy Bolt. It used to be different, but that's currently what we've seen in the past 12 months or so. One thing that I really want to stress is that GM will give good cash offers on cases that you may not even think will qualify under the lemon law. All the time we have people reaching out and thinking that they may not qualify, but a friend encouraged them to reach out to us. And when we speak to them, we're like, absolutely, yeah, we definitely can get you a settlement. And they're surprised. And then we spend a few months working on the case and we write that check to them and they are thrilled. Really quick, if you're getting value out of this video, then make sure to subscribe to support the channel. And if there's any questions that you have that aren't answered in this video itself, then drop them in the comments below and we'll cover them in a future video. So what exactly does a lemon lawyer do for you? Practically speaking, we handle your case from A to Z. Very little involvement is actually needed from our clients, other than getting us the documents that we need to evaluate a case and to eventually negotiate a case. These are things like your purchase or lease agreement, your repair orders, your registration, proof of out-of-pocket expenses. And once a repurchase is offered, then we later need your payment history and your payoff quote so that we can make sure to get the exact numbers right to work into your settlement. But that's what any lemon lawyer would do for you. What a good lemon lawyer will do is more than just pushing paper or even negotiating your case. They are taking cases and they are improving the quality. They are improving the strength of the case, sometimes even before the case starts. Think of there as being 3 possibilities that any one case could fit into. The first is that there is no case. Maybe there's been no repairs quite yet. The next is you have a potential case. Maybe it has some strengths, maybe it doesn't. The third is that you have a strong, clear, black and white case. We're always trying to move the cases up one notch. So let's say that you have no case quite yet. We're either trying to move you over to have a potential case or give you very clear instructions on why you don't have a case so that you can have some peace of mind. If you have a potential case, then we try to encourage you to take the steps that are needed to now have a stronger case. That may be, for example, taking your car back in for further repair if your issues are continuing. Or maybe it's to give you advice to take pictures or videos or audio recordings of issues that are persisting. One of the biggest values we can add is taking a strong case and turning it into what we would call a civil penalty case. That's where we get not only a buyback, but additional compensation from the manufacturer for some mishandling of your case. And lastly, something very important that we pride ourselves on is setting expectations. Because if you're going to be on a journey with us throughout your lemon law case, which will likely take several months, it really helps to know what step your case is currently in, what's coming next, how long in between these different stages, just so that you can understand what the process is and you're not completely in the dark. Is a lemon lawyer actually free? Do they charge you anything? If you're watching this, you probably have seen an advertisement advertisement where a lemon lawyer is claiming that you don't have to pay them anything. Is that actually true? The answer is yes, it is true. You don't have to pay attorney's fees in lemon law cases. That's because the law says so. The law says that the manufacturer is responsible for your attorney's fees. This can sound too good to be true, but this is actually somewhat common in consumer laws, lemon law being one of them. It's because the lawmakers understand that the car manufacturers, these are multi-billion-dollar companies. And you as average consumer, you don't have the same resources to be able to pay attorney's fees. So the law says that because the manufacturer caused your problems, they're the ones that are responsible for paying your damages, your expenses. Only situation where there's any sharing of money between the attorney and the client is if we're able to recover you civil penalties. I mentioned this a little bit earlier in the video. Civil penalties are when we can recover you not just a buyback, not just a refund of your money, but something above and beyond that. It's usually because there was some mishandling of your case by the manufacturer. Now let's get into the topic that you've been waiting for, GM's most effective defense strategy to lemon law cases. So think of GM as this huge behemoth. They are a massive company. They are the largest auto manufacturer. They make the most cars, and statistically, they have the most lemon law cases filed against them. Their lawyers are totally overwhelmed. So if you're GM, what kind of defense strategy could be effective if you're so overwhelmed with these types of cases? Delay. GM will move as slowly as legally possible. And this is effective in many ways. The most obvious example of the strategy being effective is when a lemon law claimant, someone that's bringing a lemon law case, gets exhausted by the whole process. They feel like it's taking too long and that there's no progress, and that eventually gets them to either decide to accept a lower settlement offer or to drop the case altogether. GM's strategy is not that sophisticated. They're just moving slowly. So the response, the counter to this strategy is also not that sophisticated. What we do is we educate our clients. Just that little tweak makes the world of a difference. By letting our clients know that the process will take long, that sets their expectations, that gives them a little bit more patience, and then GM's strategy won't be effective. And those who wait it out actually get paid quite handsomely, because when GM settles cases, they pay well. Honestly, this video could be 3 hours long because there's so much to cover about the lemon law. There's so much to cover about GM specifically, but hopefully by watching this, you get a little bit more insight into the lemon law. You get a little bit more insight into how GM approaches these cases and their specifics of working against GM. If you have any questions at all, or if you're experiencing car problems, we really want to hear from you. So please use the link in the description to connect with our team so we can evaluate your case, we can give you a consultation, we can point you in the right direction, and give you advice on how to improve your case. To continue learning more about the lemon law and how it applies to other manufacturers, go ahead and check out one of these videos right here.